None, sir.
Will you then swear that the evidence you're about to give will be the truth, the whole truth, nothing but the truth? Raise your right hand and say, "So help me God."
I do, so help me God.
Thank you. You may be seated.
Mr. Beggar, I was just checking. Some of the stuff has been canvassed by Mr. Mahloele and possibly Mr. Moleketi. So maybe there could be some places where we just skip and all that. Yeah?
Yes, we can
You
do
will
that.
just see how you deal with it then. Yeah?
I'll do that.
All right, thanks.
Thank you, Mr. Ledika. Mr. Wheatley, you have before you your statement, which runs from page 1 to page 15. Is that correct?
That's correct.
And do you confirm that the contents of the statement are correct?
I do.
Perhaps if you could just start reading your statement, as we've done with the other witnesses, and then, as Commissioner Ledika has indicated, we'll jump over parts that have already been dealt with in greater detail by Mr. Mahloele.
Thank you. My name is Warren Gregory Wheatley. I am 40 years old. I am a businessman, a chartered accountant, and a certified financial planner. My qualifications include being a chartered accountant, a certified financial planner. I also hold a postgraduate diploma in corporate finance, postgraduate diploma in financial planning law, and a postgraduate diploma in auditing. I am one of the founders of the Lebashe Investment Group. I'm a beneficial shareholder and an executive director of Lebashe. I'm also its chief investment officer. In addition, I am a non-executive director of Alawani Capital Partners, Brawl Property Group, Lakamva Resources, Rainfin Pty, and Legacy Home Solutions. I serve as an independent trustee of the Telkom Retirement Fund and chair of its investment committee, which has in excess of 40 billion in assets under management. I've worked as an investment banker and wealth manager at ABSA Capital, where I managed a portfolio of ultra-high net worth families and their investment decisions. Prior thereto, I played various roles within the institutional consulting and actuarial business of Alexander Forbes, where I was head of one of its consulting and actuarial branches, having consulted to a range of its high-profile corporate clients. I've prepared the statement as a response to the allegations made by Mr. Batubonki Harrington Holomisa during his testimony before this commission on 20 March 2019. Mr. Holomisa makes a number of allegations against Lebashe and me that are false and highly defamatory. This is not the first time he has done so. My early history. From May 2003 until May 2011, I was employed by Alexander Forbes, and from June 2011 until June 2013 by ABSA Capital in its ABSA Wealth division. One of my clients at ABSA Capital was Mr. Tsepo Mahloele. In 2013, I left ABSA Capital and set up an independent advisory company called TSS Capital. Its function was to advise on the structuring of deals and on mergers and acquisitions. At approximately that time, I advised Mr. Mahloele on the structuring and finance of the Capitec share purchase, referred to in his evidence and further below. For the purposes of the Capitec transactions, we had decided that a special purpose vehicle would be set up. And for this reason, a company by the name of PetroTouch was established in 2015. The name of that company later changed to Lebashe. Lebashe has always been and remains a 100% black-owned, unlisted investment holding company. It has 3 directors, Mr. Moleketi, Mr. Mahloele, and me. It has an experienced, multifaceted management team and has grown significantly since inception. Its vision is to become a leading African investment company by focusing on financial services. Its core aim is to create a balance sheet that will outlive its creators and produce multi-generational wealth by establishing a conglomerate of companies operating collectively. Lebashe has a number of investments. These include 8.4 million Capitec shares, approximately 29% of EOH holdings, 74.92% of Rainfin, 28.73% of For Africa Exchange, and a number of others that I haven't mentioned. These were specifically raised by Mr. Olomisa, and that's why a specific reference has been made to them. The Capitec share transaction. As previously testified, Mr. Mhlule was one of the beneficial shareholders in and a director of a company called Coral Lagoon. Coral Lagoon owned 10 million Capitec shares, which it had purchased for 30 Rand per share. For a number of reasons, it had approached the PIC with an offer to sell some of these shares, with the result that in February 2012, in a fully publicized transaction, the PIC purchased almost 5.3 million of these shares at just over 156 Rand per share. I add this transaction was widely published in the media, but more specifically in the Johannesburg Stock Exchange SENS, which is their news network. As appears more fully below, Lebashe was the purchaser of these shares from the PIC, and later another parcel of shares from Coral Lagoon, making it today one of the largest stakeholders of Capitec. Capitec is a South African retail bank whose core focus is to simplify banking and banking products for customers. Its differentiating features from other banking services include low bank fees and a simple, easily accessible internet banking application. I will now deal with the first Capitec transaction. On 29 February 2012, the PIC acquired 5.3 million CPI BE shares from Coral Lagoon at a price of 156 Rand per share. For the sake of brevity, I will continue calling the 5.3 million Capitec shares, and will round off share prices. The PIC had reached an agreement with Capitec, essentially that the shares would, A, be on-sold by the PIC only to another BE investor. This is what we refer to in the industry as warehousing. So the intention was never to be a long-term holder of these shares, but to find and on-sell them to a BE party. And B, that sale to such an investor would take place within 5 years. The PIC held the cap...
Mr. Whitley, a question here. In terms of warehousing, was the PIC BE credentials quite good to sit within that company, Coral Lagoon, to be part of that consortium, basically?
The PIC specifically, and we had this in evidence before and it's verifiable independently, have set up the Isibaya Fund, which has almost perfect BE credentials and are used to facilitate and this fund is used to facilitate BE transactions, and is a perfect vehicle for warehousing and facilitating BE transactions. And when I say near perfect BE credentials, I mean in terms of the BE codes and the various categories of ownership desired by those codes.
Okay, all right.
The PIC held the Capitec shares for a period of 3 years prior to the offer by Lebashe. On the 23rd of February 2015, Lebashe, being a 100% black-owned entity, sent to the PIC a fully funded and unsolicited offer to purchase the 5.3 million Capitec shares. The offer presented by Lebashe was supported by a fully funded scheme from Investec Bank, sufficient to cover 100% of the purchase price, including all transaction costs.
That's another question there, sorry to jut in there. Who were you dealing with at the PIC? Who were the main parties, though, or the top parties that you were dealing with that time?
As is common in business, The offer to purchase was directed to Dr. Dan Machila, who then directed us to a team of analysts who assessed the business merits of our application. On the 4th of March 2015, a counter-offer in respect of the 5.3 million shares made by the PIC in response to our original offer was received and duly accepted by Lebashe. The share price at which the agreement was concluded was calculated at 3.25 per share. The first set of agreements in this regard was concluded during April 2015.
Mr. Wheatley, can I stop you there? Once Mr. Machila had referred your offer down, what was the entity with which you dealt, and who were the people that you interacted with?
I believe it was the area within the PIC that specialized in unlisted investments, more specifically employees who fell under the Isibaya fund banner, and more specifically Mr. Thurston Moodley, who was one of the investment professionals that we dealt with.
Can you remember a name? I'm sure we can find it, but can you remember some names there?
The team at the time was headed by, there was a large team made up of compliance, investment professionals, and legal. The legal guy was a gentleman by the name of Cabello Mabe. There was Mr. Mervyn Muller, Koketso, sorry, the names escaped me.
Mabe, I think it's Mabe.
Mabe,
Yeah,
correct.
yeah. Okay. All right.
Our day-to-day interactions were, however, with Mr. Thurston Woodley primarily.
Okay. All right.
There was a time lapse of some 2 months due to the various approvals required to be obtained from both Investec and the PIC. By the time the transaction was to be executed, the share price had increased to 461 Rand per share. The PIC then insisted on receiving the higher price, even though in our view it was already bound by the lower price under the signed and sealed agreements. After considering its position, which included litigation to enforce its rights, Lebashe accepted the upward adjusted price of 461 per share. This meant that the overall profit on the sale for the PIC was approximately 1.7 billion.
Can I stop you there? To calculate this 1.7 billion, you're taking the price differential in the 3 years that the PIC held the shares.
Correct.
From 156 Rand at which they bought the shares to 461 Rand at which they sold the shares, which
Correct.
is a differential of 316 Rand a share,
Correct.
times the 5.3 million shares.
That's correct.
Just to follow up there also, didn't you sort of have an agreement when you were talking to the PIC? Didn't you actually have some heads of agreements by the time, from the time you started talking up until you concluded this, in terms of the share price moves? Sometimes I think people do that and say, if the share price moves, we're not going to pay for this, or we'll pay VWAP and all the other things.
Mr. Commission,
Am I clear with my question?
Yes,
Yeah?
yes,
Okay.
you're very clear. I can explain in depth. I do warn you that it is complex, but if you'd like, I'd go through it. But
No,
to answer
make
your,
it simple. Just make it simple and brief. No, don't worry. Yeah.
To answer your question, the sale, an entire suite of documents agreeing the price, agreeing the method of execution, including delivery date of the shares, was all agreed in fully executed legal documents. It was only once the trade was put through the market mechanisms of the JSE that the PIC changed their position on the price.
And was the PIC legally right to do that?
We believe strongly that they weren't correct.
That they were not correct.
That they were not correct in taking that position. Our options were to enforce our rights through litigation, in which case as the funding previously raised was only sufficient to settle the lower purchase price. The Investec funding structure had been executed and was inflexible. Lebashe therefore required the PIC to fund the cost of the excess share price in an amount of 720 million. Following negotiations, the PIC eventually agreed to provide the funding for the difference, subject to strict terms and repayable within 3 years. The 720 million was loaned to Lebashe at an interest rate of 13%, which was arguably higher than any other rate paid by Lebashe to anyone else. The loan was repayable by 28 February 2018. Lebashe requested an extension to roll over the debt to the PIC, but that was refused. We then repaid the loan in full by 14 April 2018 with all interest accruing thereon. The total amount paid to the PIC, including capital, interest, and penalty interest, was 935 million. The PIC benefited from this transaction not only by an increase in the share price of 136 per share, but also by earning interest of some 215 million on the capital advanced.
Just a question, maybe you might want to deal with it later or now. Like in terms of that 720 million rand loan, what was the security package? Maybe you want to deal with it, this one and the next loan as a broad security package.
I'll deal with the question now because the two transactions, while linked, were done on different methods. So when we acquired the 5.2 million shares, our security package only required roughly 4 million of those shares to be pledged to Investec as security, which meant that we had approximately 1.4 million or 1.3 million, let's call it unencumbered shares that we offered as security to the PIC.
What was the cover then?
The cover ratio was at all times in excess of two times cover. In other words, the value of the shares at all points in time were required to cover the outstanding loan balance.
Yeah, and the cover, the Investec cover? This is the PIC cover, and what was the Investec cover ratio?
The Investec cover was not an equity-backed loan, and so cover ratios didn't necessarily apply. We used a derivative technology called a zero-cost collar, which effectively meant that the shares were, it was almost one-to-one cover, but a very different structure compared to the equity-backed loan from the PIC.
Okay, so yes, it was different, okay, all right, sure. But I'm interested in the PIC, so it's fine.
Sure. I'll move then on to the second PIC transaction, the second Capitec transaction. The events and circumstances described in the rest of the statement took place and arose over a period of about 2 years with significant and repeated exchanges on several levels of importance. The discussions and negotiations amongst the parties were complex and fiercely contested. The crux of it is set out below. In approximately mid-2016, Lebashe conceived a transaction in terms of which it would seek to acquire the remaining 4.7 million Capitec shares still held by Coral Lagoon. It was the intention to obtain all 10 million shares and then list them on the JSE's BEE exchange. For reasons internal to Coral Lagoon, however, it turned out that only 3.1 million of the shares ended up being purchased by Le Boucher. The price negotiated for these 3.1 million shares was 1.4 billion. For this, Le Boucher needed funding and was, as is customary in this industry, required to obtain such funding before an offer to purchase could be submitted. The GEPF, through the PIC as its fund manager, was then approached by Le Boucher.
Sorry, can you explain that? I don't quite follow. Did you deal with the GEPF or with the PIC? Or is it a GEPF investment?
The actual hard currency was categorically was owned by the GEPF. We dealt with the PIC in their capacity as agent or fund manager for the GEPF. But at no point did we have discussions with direct employees or staff of the GEPF.
But you're aware, if I understand you correctly, that the GEPF signed off on that to the PIC?
As far as I'm aware.
And who were the people at the PIC with whom you dealt in relation to this transaction?
In this particular transaction, we dealt with Mervyn Miller and the same unlisted team as the parameters of this investment fell within their ambit of responsibility.
When you say unlisted team, you mean the team that dealt with unlisted investments?
Correct.
Well, is it called SIPs, Structured Investment Products, or something like that?
I believe it is, yes.
Okay, all right. Next question.
Sorry,
Oh,
can I just stay with that
okay.
1 second? I just don't understand where the GEPF comes into that. Would that not have been an internal matter between the PIC and the GEPF rather than involving the counterparty?
Through the chair, the legal documents we signed were with the GEPF. So the understanding was that the loan was issued by the GEPF, but the PIC represented the GEPF and was signatory to the agreements in their capacity as agent for the GEPF.
Sorry, Advocate Liver, can we just note this for when we discuss with the GEPF? Because I'm just not sure why in some instances they would sign off on a deal and it's not the normal agreement between them and the PIC. There might have been some particular circumstance, but it's a matter for us when we raise with the GEPF.
Okay.
Follow-up question on paragraph 24, I think. Acceptance of, no. 29, paragraph 29. Coral Lagoon, preemptive rights. When the PIC bought the first tranche of shares, and when you guys bought from the PIC and then you are trying to buy that 3.1, what was happening to sort of the preemptive rights that the other shareholders in Coral Lagoon had at that point in time?
Thank you, Chair. The preemptive rights was one of the issues where I referred to complex negotiating that took place over a period of 2 years. So it's indeed true that preemptive rights existed, and each one of the participants in Coral Lagoon enjoyed those rights. Part of the negotiations that took place was discussions with each shareholder within Coral Lagoon to waive those preemptive rights. What ended up having us not acquire all the shares is that in certain cases, not only were those preemptive rights not waived, in certain circumstances, we were compelled to pay compensation to people to waive those rights. And in other cases, people just chose not to participate in the transaction at all.
Which is why you still don't have the 10 million shares which were in Coral Lagoon.
That's correct.
Yeah, okay. All right. And did you have to pay quite a lot to waive rights? You don't have to tell me the numbers and all that.
There was no outright cash flow, but in certain circumstances, we were forced to enter into a call option agreement with certain participants, which Had they exercised the call option, would have been, to my mind, excessively expensive for the waiving of those rights. It ended up not having been exercised, so it would be untrue at this point to say that that there was an exchange of goods. But certainly it had every probability of being expensive.
Okay. Yeah, thanks.
I think you're at paragraph 30.
The ultimate funding facility agreement with the GPF, and I stress through the PIC, represented all times by the PIC, was the result of lengthy and detailed negotiations, demands and exchanges, and the successive offers were reworked and reformulated a number of times to receive buy-in from the various participants to obtain final approval. The Isibaya Fund at the PIC was the organ responsible for these negotiations, and the team with whom we engaged were led by Mr. Thurston Moodley. Once these negotiations had been concluded, during August 2016, the GEPF agreed to make available to Lebashe a funding facility in total of 1.5 billion, which was to include a provision for various taxes, brokerage fees, advisory fees to independent third parties, legal fees, and other administrative costs. Effectively, the capital amount secured for this loan for the share purchase was 1.2 billion. Funding for the additional 200 million had to be found and was obtained by Lebashe from Sanlam Wealth and Peregrine. These smaller loans have already been repaid.
Question again. When we had that big spreadsheet here, it showed that about 1.3 billion was drawn down, you know. So what's that difference between the 1.2 and the 1.3?
The difference would relate to the PIC's own facilitation fee or advisory fee or setup fee, whatever you want to call it, which was approximately 80 million. And the difference would have been interest from the date of issue up until the date of the report.
And in terms of fees, you know, one of the big things at this commission has been fees. I don't know whether you know, corporate finance fees and everything. Were you paid any fees? I mean, do you have a corporate finance unit which was paid any fees?
Categorically not. We paid fees to our lawyers. We were represented by CDH. We paid them approximately 3.5 million. We engaged an advisory firm called One Capital, to whom we paid about 10 million. But to answer your question, we do have a corporate advisory business within our group. We decided specifically to exclude them from participating. It helps for you to assess any deal objectively. You know, when your own team does it, you struggle to see the wood from the trees. So in all deals where, you know, passion may play a role, we decide to use independent third-party advisors to assist us. But just to be clear, and for the record, and because fees were such a deliberate matter in this entire Commission of Inquiry, no beneficiaries, indirect or direct, of Lebashe or Petratouch received any fees for working on this transaction.
That 10 million to One Capital, is that, you said One Capital? I've
That's
been heard of the firm, One Capital.
Yes.
Okay, all right. So what, is it a new firm? Is it a?
Just to be sure, no, they're not a new firm. They come with incredible credentials. We use them from time to time. They've been in existence in excess of 15 years. I can't talk to their exact credentials.
It's fine, I just, yeah.
But also, to be clear, the PIC did not fund the payment of their fees.
Of the 10 million?
Yes, those fees were paid directly out of our own accumulated profits. The loan from the PIC or from the GPF included only a provision for their fees and statutory costs associated with share acquisitions, which include STT and brokerage.
Yeah. okay, all right, no, it's fine, yeah, thanks, thank you.
Paragraph 32.
The facility agreement was signed on 15 August 2016. The collateral for the repayment of the loan consisted primarily of a pledge of the 3.1 million Capitec shares, which were the subject of the sale, and which, as at the date, were valued in the market at the sum of approximately 645 per share. The value of this security was sufficient, being in excess of the amount of the loan. The term of the loan repayment was 5 years, and just for the sake of brevity, the share cover ratio, and one of the covenants of the transaction was that the share cover ratio was to remain in excess of 2 times at all points in time.
The interest rate, I'm sure you
Was
mentioned it somewhere.
13%.
13% still?
Correct.
Okay, all right.
The material terms of the loan were included in a schedule published on the PIC's website, showing the rate of the return, the amount loaned, the intended use of the funds in order to demonstrate that the terms are properly market-related, together with all its other unlisted investments.
And that's the exhibit that was handed up last week.
Correct. After lengthy negotiations and several iterations of the relevant agreements, a sale with Coral Lagoon was concluded. Given the nature of the offer, all of Capitec, the Competition Commission, and the Takeover Regulation Panel had to approve the deal prior to its conclusion. All of these entities individually approved the deal. The loan and purpose of the loan that Lebashe received from the PIC was disclosed in its widely published Isabaya investment schedule, which identified all the PIC's unlisted investments as at 31 March 2017.
That's the same document that we just
That's
spoke
correct.
about.
The current debt by Lebashe
Sorry, it's Exhibit 4.
Yes. The current debt by Lebashe to the PIC, based on the facility funding agreement, is 1.5 billion. This includes interest payable on the loan. I must state this categorically and must be part of the record. Repayments thereof are up to date, and Lebashe have not missed a single payment. As can be seen from the foregoing, as a result of both Capitec transactions, the GPF and consequently the PIC will generate a considerable profit for its clients and beneficiaries. I estimate that it will be in the region of 2.9 billion, made up as follows. The first Capitec transaction, a capital profit on the sale of shares, and the math is simple, 461 minus 156 times 5.3 million shares equates to over 1.6 billion. Interest on the loan of 720 million, this was 215 million. The total profit on the first transaction therefore totals in excess of 1.8 billion. I must stress that this is not an estimation. These are profits that have been banked and successfully accrued to GEPF beneficiaries.
Mr. Wheatley, if you could just, while you're on that point of the payments, just make mention of footnotes 1 and 2.
Correct. So footnote 1, this was paid to the GEPF, represented by the PIC in May 2015. Number 2, this was paid to the GEPF, represented by the PIC in April 2018.
So the first amount is the profit on the sale of the shares, and the second amount paid is the interest on the loan of 720 million.
Correct. Second Capitec transaction, structuring fee charged by the PIC of 17 million.
And just to be clear, footnote 3 says that was also paid.
Correct.
To the PIC in July of 2017.
Yes. And then, if the loan runs to completion, an estimation of the interest to be earned on the loan by the end of its term would be in excess of 1 billion. Lebashe, through this single transaction, would therefore have would have contributed to GEPF beneficiaries to the tune of almost 3 billion rand, or 2.9 billion rand.
When you say this one transaction, you mean both Capitec transactions?
Correct. The funding transaction described above is the only one of its kind concluded between PIC and Le Boucher, and Le Boucher does not exclusively rely on the PIC or any entity for that matter for its investment funding. Our total debt as of 28 February 2019 was in excess of 7.4 billion. Of that, only 1.5 billion is due to the PIC, which accounts for less than 20% of our funding in total. This reflects that contrary to Mr. Holomisa's unfounded claims, Le Boucher's business activities are by no means limited to our involvement with the PIC. Le Boucher has many other clients and partners under our umbrella and stands securely on our own 2 feet, quite independently of the PIC or the GEPF. As required by the agreement concluded...
Just a question, sorry, question. So in terms of the 2 transactions that you did with the PIC, they were structured within various special purpose vehicles with Le Boucher and the PIC owning the shares?
That's correct.
2 vehicles, I would gather, yeah?
Yes, two independent vehicles.
All right. So the PIC doesn't have direct shares in Le Boucher?
Absolutely none, no.
Okay, and the loans are in those special purpose vehicles?
That's correct.
Okay, all right.
As required by the agreement concluded with the PIC, Le Boucher has reported to the PIC with the following reporting documents and will continue to do so for the duration of the agreement. Audited financial statements as at 28 February 2016, 2017, and 2018. Our audit for the year end 28 February 2019 is currently conducted. We provide unaudited quarterly statements of financial position per quarter. The last submitted in the 4th quarter of 2018 and the report of the 1st quarter of 2019 was just sent out a day or 2 ago. And we also submit a quarterly environmental, social, and governance report, the last submitted in the 4th quarter of 2018. And this report highlights compliance with other requirements of the deal, including the number of jobs created, adherence to corporate governance principles, and sets out our social responsibility initiatives. I'll pause here from the statement just to reflect that one of the themes of some of the other transactions under scrutiny was the lack of financial or other reporting. I'd just like to confirm that our reporting is completely up to date, including specifically audited financial statements.
And this is the Capitec part, the Capitec part, isn't it? The
Now
SPV.
we present consolidated financial statements, which include all Le Boucher subsidiaries, which includes, with necessity, the 2 tranches of the Capitec transaction.
Oh, all right.
Paragraph 40, the PIC did not fund any of Le Boucher's other acquisitions, and there are in excess of 8 of them. It is important to note that the PIC publicly discloses all its investments. The names of the borrowers, the full nature of each transaction are fully identified and disclosed to the public. In addition, the PIC reports on its activities to Parliament's Standing Committee on Public Accounts, or SCOPA, and to the Standing Committee on Finance. Members of Parliament, including Mr. Holomisa, are able to access this information readily. It is public knowledge that the value of the assets of the PIC is some 2 trillion. The PIC has approximately 119 private companies, in which it invests a total of 147 billion. Of that, as appears above, Le Boucher has been funded to the extent of 1.5 billion, which constitutes less than 1% of the PIC's investment in the 119 private companies. This excludes the PIC's investment in listed companies, which accounts for some 12% of the listed capital on the JSE.
Mr. Wheatley, before you move on, The next section of your statement deals with Lebashe's other commercial relationships. And I'm talking about from paragraph 43 through to 47. I don't think, subject to what the Commission requires, I don't think it's necessary for you to read these paragraphs of your statement into the record. If you want to just briefly summarize what this relates to, I think that'll be sufficient.
It's fine, but I need to go back to 42. 42. This statement is generally correct, but you will find that the PIC will fund one grouping of people in 4 transactions. You see, so you might say it's 119 private companies, but you might find out of that, 3 or 4 belong to one group of people and all that. You know, so technically, when you look at total funding, the number shrinks a bit. Am I correct? Okay.
I would agree with the comment. However, as far as it relates to Lebashe and our investments, we've received. One of our investments was funded by the PIC. It came through in 2 separate tranches, but it remains one investment. So, to my mind, we remain one of 119 companies, and the funding extended to us represents less than 1% of the capital extended to similar transactions.
I would disagree and say it's 2 companies because it's 2 transactions, but that is a different matter. Yeah, would you say that? The SPVs?
I would
It's 2
concede on
companies.
that matter,
It's
yes.
2 companies, it's not 1 company.
Just for the Commission
Different
to
transactions done in different times and all that. Different packages, different share prices and all that. Yeah?
the use of separate companies was purely for the structuring of the various debt packages
Yeah.
and to ring fence risk.
Yeah, but it's fine. It's not a big point I just said. Yeah, that's fine. That's fine.
I'll deal briefly with Lebashe's other commercial interests. We list from paragraph 43 all the way through to 47 a list of a number of our other transactions. The point simply to make here is that none of Lebashe's other investments have been funded by the PIC.
And these companies you've listed because they've been mentioned previously by Mr. Holomisa.
They've been previously listed in a diagram called the spider web of intrigue and other names of that nature. I'll then continue with the Chair's permission to the effect of Mr. Holomisa's conduct, starting with paragraph 48. Mr. Mahlule and Moleketi have given evidence as to the very destructive and hurtful nature and the effect of Mr. Holomisa's utterances that depict us as greedy, unscrupulous, and uncaring fat cats. I stress that these unfounded allegations have been extremely damaging to all of us, both personally and professionally. On each occasion that he makes an allegation, we have had to spend inordinate amounts of time reassuring our clients, customers, and bankers that the accusations are baseless. We have had to spend considerable amounts of resources in defending ourselves and our reputations in a court process and now before this very commission.
Can I, sorry, yeah. I wanted to go to paragraph 47. Actually, you skipped a bit more. So can we please go to 47?
Yes, Alawani Capital Partners.
Yeah, Aluwani Capital was given money by the PIC. Just explain, just take us through that, please. I think it's important.
Okay. So through the Chair, I'll read through and then explain. Lebashe's directors identified Alawani as a strategic partner because it is an active investment manager with research and product capabilities across all asset classes. Alawani is an independent black-owned investment management business that aims to make a lasting impact in South Africa and the rest of the African continent. It is registered with the FSCA and is an improved investment manager in terms of the Financial Advisory and Intermediary Services Act. Alawani came about as a result of the unbundling of a portion of Momentum Asset Management. First announced in July 2015, which then led in turn to the creation of one of the largest black-owned asset management companies in South Africa. Mr. Mahluli, Mr. Moleketi, and I together, through an SPV called Main Street, jointly hold a 20% equity share in Alawani. 40% of the company is held by its management, and the remaining 40% by MMI. Lebashe, as such, does not hold any shares of Alawani. This is simply a personal investment by the 3 Lebashe directors. 50% of the cost thereof was funded by us personally, and the balance of the 50% through loans to us by MMI in a BEE vended finance transaction. But now to address your question more specifically. I think I need to place in context the asset management environment in addressing this query. In South Africa today, there are probably around 44 black-owned asset managers. I've mentioned that I've worked extensively in the employee benefits arena and more specifically giving investment advice to trustees who make investment decisions on behalf of retirement funds. It is a categoric problem in the country that the boards of trustees have been reluctant to support new black asset managers. Instead of the government, through various regulations which exist, compelling trustees to support young black asset managers, they have instead left it to corporate SA to promote transformation in this area. This transformation has been pedestrian at best, and I would refer the Commission to a report issued by an asset management business called 274. The results, broadly speaking, is that less than 10% of a multi-trillion rand industry is managed by young black asset managers. The PIC, as an instrument for transformation, particularly in financial services, have created an incubation program. Alawani, as one of 44 or in excess of 44 black asset managers, have received an allocation to manage a portion of the PIC's listed assets. I'll pause here to advise that these allocations are typically small relative to what is the norm in pension funds and typically below market-related fees. Every single one of the 44 participants or active black asset managers has an allocation of some sort. I would pause to say that I would struggle to name a single asset manager in the country, white, black included, that does not have an allocation by the PIC. To single Alawani out is simply unfair and disingenuous. It is one of a number of asset managers in the country who have an outsourced mandate from the PIC. You must remember that as an asset manager, they manage over 12 trillion in listed assets, and the job, quite frankly, would be outside of the scope of any one of our asset managers. And to that end, Alawani has received an allocation from them, and it's a service provided to the PIC, and we are just one of 44 black asset managers who deploy such service, and one of thousands of asset managers in the country who provide such a service to the PIC.
So are you saying then that the PIC angle basically is just as a client of Alawani and no other issues and all that?
That is correct.
no link, there's nothing untoward according to you, it's just the PIC is just a client of Aluwani.
Correct. We manage a mandate for them. That mandate is performing well. The mandate, like I said, a similar mandate has been given to almost every asset manager in the country. There isn't a single asset manager in the country other than your startups who could make a claim that they don't manage pension fund monies on behalf of the PIC.
Okay, yeah, thanks. Thank you.
Mr. Wheatley, just to make it clear, it's not a payment of money by the PIC to Aluwani. It's a mandate to manage an asset
That's
That
that is
correct.
under management by the PIC.
That is correct.
Yes, and the PIC does pay fees, but for the service that.
For the service they render, the same way they pay their auditors or their secretarial services or for brokerage or for research, it's a similar situation. In this case, we provide a service to the PIC for which we are remunerated. I must stress, however, on
We've
this
been-
point,
Sorry, yeah.
I speak for Aluwani. I must stress that this arrangement is in place with almost every single asset manager in this country. There are very few who could say that they don't have a mandate from the PIC.
Sure, thanks.
Paragraph
52, I think.
Paragraph 52.
Yeah, no, it's fine.
We have had to spend, 51, we have had to spend considerable amounts of resources in defending ourselves and our reputations in a court process and now before this commission. Family and friends of mine and my family are similarly embarrassed and humiliated daily, and my partner and I are continually harassed and harangued on social media, practically on a daily basis, as a result of Mr. Holomisa's campaign against us. It is very difficult to quantify in money the losses we have incurred and continue to suffer as a result of Mr. Holomisa's unrelenting campaign against us, especially the cost of lost opportunities due to the damage to our reputations, which are of course critical in the financial services arena. We shall nevertheless pursue the claim for damages we have instituted and by way of the confirmation of the interim interdict in due course. In conclusion, given the detailed exposition of Lebashe's history, conduct, and integrity, its overall success and growth, and the commercial arrangements it has entered into over the years, there can be no doubt that Mr. Holomisa's statements are without any factual basis at all, and that he has grievously misled the public and this commission. I accordingly request the commission to treat Mr. Holomisa's testimony with great circumspection. And I, of course, remain available to assist the Commission further in its work if needs be. Thank you.
Thank you.
Yes, Mr. Liberal.
Thank
you
you,
have any
Mr.
questions?
Commissioner. I have no questions. Perhaps I must just place it on record that in my respectful submission, 90%, if not more, of this submission is not within the terms of reference of this commission.
Yes, then thank you very much, Mr. Wheatley. Thanks for your time and thanks for coming to testify before us. Certainly, certain issues have been made clearer to us. I do hear Advocate Libba saying your testimony is outside the terms of reference, but thank you very much, and thank you for saying to us that you'll be available should you be required again.
My pleasure. Thank you.
What did we say, Mr. Berger, this affidavit from Leonardo, and the other names is exhibit number?
It's Exhibit 8, Chairperson.
8.
Yes.
Yes, thank you.
Chairperson, all that remains is for Mr. Mahloele to return to the witness stand to complete his cross-examination by my learned friend. Good afternoon.
I suppose you still have an idea as to the fact that you have to take the oath.
Yes, Chair.
Do you still swear that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth? So help me God.
So help me God.
Thank you. You may be seated. Yes, just for the record, the witness taking the stand again is Mr. Mahloele.
Thank you, Mr. Commissioner. Mr. Mahloele, I believe you're freshly back from London.
Yes, Commissioner.
I suppose it did
No, not on any health or leadership business. Okay.
You were not requested to advise on Brexit.
I offered.
You were present this morning during the testimony of your colleague, Mr. Moleketi.
Yes. Through you, Chair.
And you heard me questioning him on your movement to Harith.
Yes.
Just to get back to that part of the evidence, was there any process in place to identify you as the chosen person to be the jockey of this new venture? In other words, were you interviewed? Were other people interviewed? Was it open to other fund managers to apply for the job?
Okay. Through you, Chair. I think, perhaps putting this thing in perspective and in the way it works when you raise funds. As I alluded to earlier on in my last week, there was a process of resigning from the PIC. At the time, as you can imagine, it was that thing, and then there would be other things that I was actually also going to look at, as is clear from my other interests, because there was the issue of managing risk. I then contracted with the Facilitation Trust. And as also has been alluded to earlier on, the idea at that stage was that an entity which was going to be very collaborative with other players, with other countries, was envisaged. And that's why it had all the sort of things which were linked to it, like so how it should be and what. And during that process of the Facilitation Trust, as I alluded to earlier on, we looked at other partners, we looked at this, we went around raising funds. Other entities, said they would also like to participate therein, and that was the nature of that at that time.
So
And when
sorry to interrupt you.
Okay.
Just to get back to the basic question I asked you. Nobody else was considered for this position by the PIC.
Yeah. It's for the Facilitation Trust, I was the one that they contracted with. I don't know of anybody else they talked to because perhaps of my skills. For the Harith fund managers, at the time, I had raised the fund. I had interacted with all the investors. I had negotiated all the terms. And in fund management or in private equity funds, I think that is the process that is used to raise funds. You get one or two people or three, they start going all over the place to people that they entities that they've interacted with, and they start then raising a fund. That's the way it happens. And once that process is now done, you invariably find that that team then sets up the management team. And that's the same way it happened in our case, that when that happened, I had interacted with all the investors, I had set up the fund, and I was then appointed as that guy.
As the CEO.
So all in all, there was no process of interviewing anybody else either, or the position being put out there to say that we need somebody to act as CEO or whatever position of the Facilitation Trust.
From a PIC point, I don't think so. Whether other people were considered or they would have, I wouldn't be aware, but I think at all times, going through this was definitely putting my hand up that to the extent that one is doing this and raising a fund, one would like to actually lead it going forward. I mean, you do that. I do not know of many instances where people go, they raise a fund and then give it to somebody else to manage. So to that extent, I would say I also put up my hand or showed my intention that to the extent that this is successful, I would not mind to be part of, manage that.
I'm not blaming you for getting the job, Mr. Mhlele, not at all. I'm just asking, there was no process in place, people interviewed. It was a foregone conclusion that you will do the necessary and you will set up and consult with people and you will be appointed the CEO.
I don't think it was a foregone conclusion. And why I would say that is exactly because of, if you see all the other challenges which went with getting this even fund manager entity together and deliberations which came with that. And I think to perhaps argue that it would be a foregone conclusion would perhaps also take away from the investors' belief in their minds that perhaps that this is the team that TEPO's going to put together.
But that the position is that you were suggested or selected by whoever in the PIC to go and set up this vehicle.
Yes.
But you also heard Mr. Moleketi testifying about a meeting, a high-profile meeting with people from Nigeria, ministers of finance, where you were also present. Is that correct?
That is correct.
And the whole idea was this new initiative, African states buying into this concept. But in the end, nothing happened because Nigeria, I believe, was not interested.
Yeah, the partnership with Nigeria didn't work. That's when then we went to other parties, and then that's that's how it worked. But with Nigeria, it didn't work. I think Nigeria subsequently went also on their own to establish their own separate fund.
Okay, and then you and your team went out on a roadshow promoting this whole idea of the Renaissance. And in the end, it was also not very successful. And I'm not blaming you, I'm just asking, looking at the numbers and the figures, less than 10% of funds were provided by other investors.
Successful or not, my view would be that this was successful. To the extent that you could even get SNIT to even commit the $10 million that they did, I think in itself meant something. To the extent that you could even get South African entities controlled even by some foreign companies at the time to commit to this fund and to start building this asset class on the continent, I would think that has been successful. And if I look at the impact that these two funds have done up to now, you're now starting to get a market that is developing very well on the African continent. You're now starting to develop a secondary market. 5 years ago, you couldn't even think about that on the outside of South Africa. And we were exactly using some of those lessons and experiences learned out of South Africa and in the region to go and implement elsewhere. And I would think 13 years later, and I look back, I would say it has been successful. If you look at the people that this fund has had an impact on, and I think the benefits for South Africa too are great. To think that like what it can, you know, contribute to the development of the continent. And we always talk about the combined amount between the two funds of $600 million as if it was like put on one day. This is like a drawdown fund, capital which is drawn down over, at least in the case of these two funds, is going to be drawn down over about 16 years. So when you look at that amount of contribution, or within the bigger space of what from a GPF point of view, or like what from South Africa is, in terms of like the development of the continent and South Africa, because now you even find 50% of that portfolio is here. I think it just improves
I think we've heard you. Your answer is, I think it was successful, and therefore I don't agree with you that it wasn't as successful. Am I correct?
Correct, Chair.
Thank you, Mr. Mahlele. Just a last question, and as a matter of interest, we heard testimony by Mr. Moleketi about this fund that was established in 2013 in Marrakesh, 25 member countries. Do you know what the amount of that fund is?
The Africa 50 Fund. You know, I think like the other, I don't know what the actual amount is, but what you find is that you find countries pledging to the fund. And those pledges, if you think that they are from not even funds or even the pension funds, they're from the countries, those pledges in total, I do not believe that, as that today they're perhaps in excess of 700 million. I'm not too sure. But also if you look at that initiative, and not to like cast judgment or anything, and the extent of like what it tried to like, what it is achieving, and I'm sure over time it will, because the continent is, and the amount of transactions they've done, I'd like to think that the Hereth team has really done an incredible job of investing in the assets that they've done across the continent.
Thank you, Mr. Commissioner. I have no further questions.
Thank you. Any further questions, Mr. Berger?
Thank you, Chair. The correction.
This is the amended one.
Yeah.
I need 2 other copies of that.
And that correction, yeah.
Just point it out. When they've got it, just point that out.
Thank you, Mr. Commissioner.
Are you going to be long?
No, I'm not going to be long. We noticed that the statement that was printed on or that was put up on the Commission's website did not contain the corrections that were made during the evidence of Mr. Mahlele. So we've had prepared for the Commission, if it wishes, an amended statement which does record all the corrections that were reflected in Mr. Mahlele's testimony. And if I might hand that up to the Commission. The top statement, there are 3 copies. The top one has been signed by Mr. Mahlele again.
Yes, I'm sure, though, that the record of the evidence that the witness testified to would be on the website
As well, yes.
as well. But you may hand those in.
Thank you. And if I can just point out one correction. Well, I'll re-examine Mr. Mahlele on it, and then you'll see the point I'm making. Mr. Mahlele, at page 14 of your statement, this is the new statement that's been handed to you, paragraph 44. In your original statement, you said there that Hereth GP became active in October 2013. But in the revised statement, the statement is that Hereth GP became active in October 2012. Do you see that?
Just give me those pages again, please.
It's paragraph 44 of his statement. The paragraph number remains the same, but in the original statement it says there that Harith GP became active in October of 2013, whereas in the statement that I've just handed up, the change is that Harith GP became active in October 2012. It seems as though there's there is a difference, and I just want Mr. Matluela to explain that.
Okay, if I may, I think the October 2013 was supposed to be October 2012 from our side, nothing more, nothing less. And also just to make it clear, to say Harith GP became active in October 2012, I think that's when we actually registered the shareholding of PIC. Because between the approval and the recommendation of the board and then the approval by the board and recommendation to the minister was, I think, a time period of between April and October. But Harith GP became active on the 1st of April 2012 in terms of starting to operate according to the new subcontracting agreement.
The letter that you're referring to, or is at page 99 of Exhibit 3, where in a letter dated 23 April 2012, the Minister of Finance confirms that the PIC's shareholding in Harith GP will be 30%.
Yes, Council, because I think the recommendation by the board was made sometime in March, April, and then the approval only came through in October. So you could only register the PIC share once the PFMA process had been followed.
So what should the date be in paragraph 44 then, or month? Should it be April? Or
Chair, perhaps at the time what I was trying to say that maybe was as of October 2012, then the PIC got its permission through Minister Gordhan to take up the 30% in HGP. Whereas the becoming active and starting to trade and moving the management agreement to HGP by HFM happened on the 1st of April 2012. So it's just the legalese around that.
No, the approval came through in April of 2012 as well. If you have a look at the letter.
No,
at page 99.
If you check that, the letter is actually from the PIC, and it's actually addressed to Minister Pravin Gordhan. And the recommendation, as you can see on page 100, is then made by the PIC. And then it's signed by their lawyer at the time, the legal division, the CFO, the CEO, and the chairman. But you do not have a ministerial approval. The ministerial approval to enable to do that is on another page. That's page 103.
Oh, yes, I see what you...
If you look at that, that's 15 October 2012. Minister Pravin Gordhan giving the approval to PIC to take up the 30%. Only then could you register the PIC's 30%, because then the PFMA process is fully followed.
I see that. I just have three further questions that I want to ask you. There was a lot of questioning about your identification to run with the PAIDF. But I think there was some mixing up of different identifications into one. I think the real question is, and if you know, please say. If you don't know, you don't know. I think the questions are referring to the very first time you were identified for this role. In other words, when you were still at the PIC, you were identified by the PIC as the person to take on this task of establishing this vehicle, which in its original form was the PAIDF Facilitation Trust. Correct? So the question is, do you know how it was that the PIC came to identify you, whilst you were still at the PIC, as the person that it wanted to run with this task?
I'd like to think that I had gained experience in terms of infrastructure finance across the continent from my work at whether it was CDC or Development Bank of Southern Africa or other things, or even at the PIC. And I think it was and also on the basis that we had it also in my work, besides making direct investments, also invested in other funds, so knew what it would take to do that. But this was not a foregone conclusion, I would think, because as I said, first the facilitation trust was created. And in that facilitation trust, I'm sure had we gone ahead with the perhaps partnership with Nigeria, there would have been contestation in terms of who is going to head this, who will do this. And as I said, that's how it unfolded. And as of 2006 and 2007, I would like to think that from a PIC process point of view, they followed what they believed was the process for them.
Well,
And then from my point of view, with regards to like contracting with the facilitation trust, that became a new contract for me, which was going to be like for a year. Had it not succeeded, perhaps I would not be sitting here today.
Perhaps you can't answer this question, but you're answering the question of why they chose you. I'm not asking why they chose you. I'm asking if you have any knowledge as to how they chose you. In other words, what process, if any, was followed by the PIC in coming to the conclusion that you were the person to be identified. Do you have knowledge of that?
I'm not too sure how to answer it, or whether the PIC issued an application for the job. That I don't think happened. I think I ran with the thing from a facilitation trust point of view, and on closure of this thing, then there was a fund manager to be put up, and I had been the one who had done all that up to that stage. So I think that's how that happened. That's what I'd like to think. And I'd like to think that also, had the many other investors besides GPF, in the form of Old Mutual, ABSA, AFDB, I'd like to think that had they any perhaps other concerns, or if they didn't want to, I do not think that anybody forced them to like make the commitment to the fund. And let me perhaps just like make another distinction clear. In this case, from a partnership point of view, PIDF 1 was structured as a vesting trust. It had all the bells and whistles to try and protect the investors in terms of like the investments chosen, in terms of like the process through which, how the fund is managed, and also that they had see-through to the, to the assets. And that's why it was actually structured as a vesting trust. Then, it then enabled the investors to stay very close to the investment process and do that. And with first-time fund managers, this is a norm in many of the instances, that the investors then want to stay close to the fund manager or to the process to ensure that this happens. Otherwise, you wouldn't even have any new fund managers perhaps coming up.
Let's do it this way. Did anybody from the PIC tell you that we'd like you to go and set up this new vehicle?
I think at the time I interacted with the CEO and the board about all these initiatives. And from that point of view, that's why there were also all the regular, reportings and everything to,
Can
to
you,
the board and to the National Treasury.
can you let us in on the discussions or communication you had with the CEO?
No, I do not think it was, I will have this job or you must give it to me or whatever. And as I said, I think the evidence, I don't know, I can't maybe say evidence or history.
Let's make it easier.
Yeah?
You said there were interactions between you and the CEO. What were they? What were those interactions?
That I would, start running with a facilitation trust, partner up with the Nigerians, and do that. And when the HFM was set up, I do not actually remember a time where we said, no, I will be the CEO. I think from the investors' point of view or from everybody, it was just taken as a thing that is what I had been doing. And they had put in mechanisms from a board point of view, from a governance point of view, to ensure that everybody would be comfortable around the table. There wasn't any side agreement of any sort.
Yes, Mr. No, they wouldn't be side agreements, but I was interested in the interaction.
No, I think I had the interaction, but there wasn't any agreement which said, no, you will have the job. It's a through pass.
All right. My other question is, when you last testified, Commissioner Marcus took the view that, or prima facie took the view that in relation to PAIDF 1, a return on investment of some $31 million for the period of PAIDF 1 is not great. Do you have a comment on that?
I think if you look at it on the basis of having started a fund in perhaps 2007, and you then look at the number in 2018, maybe that's like the sort of view that one would come to. But when you look at funds and when they invested, they normally have what they call perhaps also a vintage. So this one would be about 10 years vintage. And then this one would be within a context, that's the way they are always compared, funds, on a 1, 3, 5, 10 years sort of basis. So this one would be on that 10, 11 years and we sort of would have been around the 2008 sort of vintage and then the financial crisis. And if you look at work done by, an entity like Cambridge and Associates, which looks at over, I think 700 fund managers in various categories and everything. And you look at the returns that achieved by the vintage of that year, that within that 10, 11 year period. The only entities which that did about in excess of about 6% was maybe in real estate, some of the REITs. But then most of the infrastructure funds did around about 1.5% in terms of net. So therefore, that's the basis upon which funds get compared. But in addition to that, in Fund 1, we also took a lot of, greenfields sort of risk. Most of the assets in Fund 1 were from scratch. So I think that increases your J-curve in terms of your ability to start turning positive and start generating cash and give that back, because you have all the investments made up front and then the fees, and then you only get the return coming out in the later years. And in this case, coupled with, yes, it's not an easy place to do business, Africa. It's greenfields, it's Africa, and it's infrastructure. But then on that basis, I'd like to think that, compared to some of those which are compared internationally and in emerging markets, we have done better than the average in terms of Fund 1. In terms of Fund 2, we are doing very well. So therefore, looking at that thing, I'd like to say that, you know, from what we've done so far, it's something to be commendable. And that's why I think you still find that perhaps even like for Fund 1, you're going to get actually a big kicker once you start, like, you know, some of this assets, if you can imagine that, you know, they've been in construction. They're big infrastructure projects for a long time. And then, you know, it's only now, I think in the next year or two, that, you know, they start turning, you know, cash positive and start yielding that. So from that point of view, and compared to the vintage of our year, and looking at what Cambridge and Associates say, I think, you know, we have done better than average within the infrastructure space.
Is this a report by Cambridge and Associates?
Yes,
Where,
an independent report.
where does that report appear?
They publish the reports like, no, I think every 6 months or every year.
Cambridge and Associates.
Yes.
In relation to Fund 2, Commissioner Marcus also took issue with the increase in the GEPF contribution of investment. That in those few years, the increase of $15 million, Commissioner Marcus says is also not great. You have an opposite view, is that correct?
If you look at that, the fund came about, you know, the fund was only established in 2014. And then you only start sometimes making you make like sometimes 1 or only 2 investments in any particular year. So therefore, you take time sometimes to draw down. Sometimes it's 1 deal, sometimes it's 2 deals. In a good year, you'll do maybe 3 deals in a year. But I think that amount of money in dollar terms is still a good investment. And also, all the money is not drawn up front. It's drawn as you make investments.
And the Cambridge report, does it cover the period spanned by both funds?
Yes, it would cover that. And in that regard too, I think we have done better than most within, you know, the infrastructure space on a comparative basis.
Thank you, Mr. Mahlwele. Thank you, Chair. I have no further questions.
I think it's important to identify what the issue is here. Because you're looking at when you are investing, I mean, here you have a pension fund that has to ensure that it is sustainable in the long term according to its actuarial valuations. And when it makes a decision to invest, whether the return is 1% or 20% or whatever those returns are, and the time horizon within which that will occur, is something that the risk management and the decision-making of either the PIC or the GEPF directly needs to weigh up. And therefore, an investment in a fund like this, because what are we trying to look at? We're trying to look at as to whether whether the exercising of the mind of those responsible to ensure that there are adequate returns on investment weigh up what they should weigh up. And therefore, the decision may well be in terms of the fund itself that your returns are appropriate. But whether that is appropriate in terms of what the requirements of the GEPF are is a different risk assessment. And therefore, what I'm raising here is the returns on this, which may be a 20-year horizon with a kick to what you're going to get in due course, is one element of what you would weigh up in that return when you take a decision to directly invest the amounts of money you are investing related to your needs. And therefore, the return needs to be looked at, 1, in terms of what you've invested in, is it appropriate, but 2, the opportunity cost of that investment versus something else in relation to what the GEPF requirement is. And that's my point. It's not the question of whether this is better than another fund doing infrastructure. It's what is the nature of the investments that are being made. And obviously, a lot of factors are taken into account. The question of investment in Africa, the need for infrastructure, transformation, there's a whole lot of issues taken into account. But all of them, in the end, have to be weighed in keeping with the viability, sustainability, and long-term equilibrium of the fund itself. And that's the question I'm raising, not whether simply this return was appropriate compared to other infrastructure funds.
But then that's really a question for the PIC and or the
Precisely.
or the GEPF.
Precisely, and that's what we've been trying to ask here, what was weighed up? Because the question here is, we invested in that, and I'm trying to understand, and obviously we will come to the GEPF and the PIC to ask these very questions, and that's why we need to understand the thinking of that investment, which is what we have been doing today.
Yes, but that wasn't a decision for Mr. Matlele to make. That was a decision.
I'm not saying it was. He's been explaining to us how the fund operated and what the returns were and what they took into account in that investment.
Indeed.
But that is one element of what the GEPF needed to understand and the PIC needed to understand, and we need to understand.
Indeed. Thank you.
Just a different question. The PIC has got an Africa mandate, I think, currently. And you guys, you got money from GPF on Africa investments, the infrastructure. Is there some clash there somehow? Or do you work together, or you focus on different things?
I think, if I may be, so maybe perhaps for the benefit of also of the commission, also, when we also looked at, it's not perhaps meant for this commission, but when we also looked at the changeover in moving from HFM to HGP, one of the discussions we also had with the PIC around infrastructure, and actually not around also like outside of South Africa, was whether we could collaborate and look at things together and do that together. And I can also say categorically, and I'm sure, if there was a memo, I remember I'm seeing, and I still have it, wherein, or not a memo, but it was one in the negotiations, we actually said to the PIC, you also now have an Africa mandate, and are we going to work together, or what is going to happen? But now we also have the commitment also directly from GPF. How then do we go forward? And we said, recognizing that the PIC had been instrumental in the seed capital in the beginning, normally you reward angel investors through that loyalty. We said you can keep 10% and we'll keep 90% and then we'll go do our own thing. Or you can have 30% and then we can collaborate. We have not collaborated much outside of South Africa. Within South Africa, we have co-invested into infrastructure assets, as I've alluded to earlier on. So that's the scenario we found. But then it ended up with that type of number. I would have wished for more collaboration. I don't know.
Okay, thank you.
Yes, thank you, Mr. Matlwele. Thanks for your time. I hope you didn't rush back from London not having finished whatever you went there for.
I left my family there, Chair.
So you'll be going back there to...
No, they must come back.
All right. Thank you so much. Thank you very much for coming here to give us what you have given us, the testimony that you have given us. And as we said to the others, if it does happen that we need you to come back to clear up something, I hope you will be available. You make yourself available.
I will, Chair.
Otherwise, thank you very much. We'd appreciate your time. Thank you.
Thank you, Chair. Thanks for having me.
You're excused.
Thank you, Mr. Commissioner. That's the business for the day. The next witness is going to be it's going to take a day. So we've arranged for her to start tomorrow, at 10. If you need to start earlier, we can do that, but otherwise we start at 10.
Yes, we'll adjourn until 10 o'clock tomorrow morning.
Thank you.
Thank you very much. Right. I suppose you would want to be excused as well.
Yes, please, so that we can also return to our families.
You are excused.
Thank you very much, and thanks to the Commission for indulging us.